Don't be chicken and beer, man. He's good to see these all the time. I got 4 or 5 shoes.
All rise, please.
All right. Have a seat. Thank you. Hey, Ben. John. The only letter, these are the only 2 letters I have. I don't have anything We're still waiting on the defendants to be brought up, so it'll be a minute. Are they up, guys? Well, they gotta bring them from over there. Because these elevators don't work still. Do you guys all have paperwork for me? It's all right, don't worry about it. It's gonna be allowed anyway, so I'm not worried about it. Is anybody live streaming today?
Three of us.
Three of you?
Excuse me, I may I approach?
Yeah.
I'm fine with it.
Just an exercise of due diligence, can I repeat those two letters?
Sure.
That's fine, thanks. Absolutely. I can stay here or I can go to my desk.
It doesn't matter to me, whatever,
As long as you don't mind. I'll-
whatever you're feeling. Everybody's cell phones need to be off and put away. I see a cell phone, you're gone, and I confiscate the phone. Before we get started, and we're off the record, before we get started, I want to remind everybody again of proper courtroom decorum. Everyone was great during the trial. I appreciated everybody's kindness and measured reactions to testimony and things that happened. I gave the same warning before the verdict, and we still had people who, and I understand it's an emotional situation. We had people who, made a show about themselves, and I'm really trying to avoid that this time. Again, this is going to be an emotional day. Everyone here is likely going to leave disappointed today, so if we could please keep our reactions. I don't expect people to have no reaction, but please try to keep it to a measured response until you're out of the courtroom. This is still a court of law. There are still people, professionals in this room that are doing their jobs, myself included, and I would just ask that everybody be reminded to remember their decorum.
Thank you.
Yeah.
Good job. Yes, sir.
That's fine.
But
I
I
assume
think it
so.
is, yeah.
And then,
Effectively, if nothing else, you know, and then,
no
I
problem.
mean.
No, I didn't, that's, I always hate when people do that, because I had a few does that all the time, and then, well, there's never gonna be an ineffective assistance. You know,
Right.
you never know.
Right, I understand,
All right, look at the Helen list. Separate counsel for each department, correct?
Yeah, John, firearms, but they work on the fire case. Right, go ahead, we can approach.
Yep.
Okay, and it's, we just wanted to make sure you knew which one they had been on.
Yeah.
Before we entertained it, so they don't have a conflict, but I just wanted to make
Yeah,
sure.
I just,
No.
avoid just because you're on this one, and I didn't know. I figured.
That's fine.
I do not even think of that.
Yeah, I'm not asking for anything.
All right, I'm
No.
just saying.
Oh, no, I understand. I understand. I do.
When you he does, but that's not because he's written brief to the U.S. Supreme Court prosecutors who get in trial appeal have no answer on the record. I investigated, indicted the prosecutor, accused myself. He can get fucked. She probably should have Mr.
Yeah, no, and what's that? It's a bold claim to be making on appeal. Sure. Yeah, no, and I didn't remember the PD, because I was lobbying, I was bringing the PD.
Just there was no conflict.
Yeah, because if you appointed,
Yeah.
then you would have a potential conflict.
Sure.
If you appointed Juwone, no problem.
Okay.
That was
Gotcha.
our lunch.
Oh, they had him initially? They had Juwone initially?
Yeah, because I remember Russ telling me that they did.
Okay.
And that was why, but they didn't leave because of conflict, so they could have gone back on. That's all.
Deputy, if I see a cell phone, I want it, and they're out of the room.
Guys, someone's got to get out of that front row, you can't sit in each other's laps. Guys, right here on each other's laps. Someone from the front row needs to step out.
Morning.
After we're done, that chair they just pulled out for him is supposed to be in here. This one can go back out.
Okay.
Not now,
Yeah, right.
later on. All right, you guys can have a seat. All right, good morning, everyone. We're on the record now in case numbers 694-514A, Juwone Deaver, and D. Jemerious Davis. Misters Deaver and Davis did go to trial on in June of this year. I should start by saying Mr. Deaver is here with his attorneys Steve Bradley and John Martin, and Mr. Davis is here with his attorney Cal Cumpstone. On behalf of the state of Ohio, his assistant, Cuyahoga County prosecutor Ben McNair, and also representing the Cleveland Police Department is Detective Lisette Gonzalez. So, back in June, on June the 11th, both of the defendants were convicted at trial by a jury with an unclassified felony, murder, with a 1 and 3 year firearm specifications in violation of 2903.02B, as well as 2941.141 and 145. Counts 2, 3, 4, and 5 were each felonious assault, felonies of the second degree in violation of 2903.11A2. Each of those carried 1 and 3 year firearm specifications. Count 6, the defendants were convicted of improper discharge of a firearm at or into a habitation or school safety zone, also a felony of the second degree. That's in violation of 2923.161A1 with 1 and 3 year firearm specifications. And each counts 7 and 8 are discharge of a firearm on or near a prohibited premises. Count 7 is a felony of the first degree. Count 8 is a felony of the third degree. Each of those carry 1 and 3 year firearm specifications. And those are in violation of 2923.162A3. We are here for sentencing today. I have been in receipt of pre-sentence investigation reports completed for both defendants. They were completed on July the 2nd of this year. On behalf of Mr. Deaver, Mr. Bradley and Mr. Martin, have you had an opportunity to receive and review the pre-sentence investigation report?
Yes, we have, Judge.
And on behalf of Mr. Davis, Mr. Cumpstone, have you had an opportunity to review the pre-sentence investigation report?
I have, Judge.
Do either of you have any additions, corrections, or modifications that need to be made?
Not on behalf of Mr. Deaver.
And not on behalf of Mr. Davis.
Mr. McNair, have you had an opportunity to review the PSI?
I have, Your Honor.
All right. I'm also in receipt of several letters that were submitted by family members of the deceased little girl, Gracie Griffin, and I have read and reviewed those as well. Councils have also had an opportunity to take a look at those as well, correct?
Correct.
That's correct.
That's right.
All right, very good. Is there any reason why we should not proceed with sentencing at this time?
So, Your Honor.
We're prepared to proceed.
As are we, Your Honor.
All right, so on behalf of Mr. Deaver, Mr. Bradley, or Mr. Martin, would you like to be heard?
Just briefly, Judge, let me begin by saying, obviously, there was a trial in this matter. The court had the benefit of listening to all of the testimony that was presented in this case, including but not limited to the testimony of Mr. Deaver. And so, insofar as you are obviously aware of all of the relevant facts and information associated with this case, it's not my intention to be redundant. I also want to note that because you have heard from Mr. Deaver during the trial, And because there will be an appeal following this case, we have advised him not to make any further statements to the court in allocution at the time of sentencing.
Certainly, and I will note for the record that both, actually really Mr. Deaver declined to make a statement to the probation department with regard to the pre-sentence investigation report. And again, I don't take any offense to that. Obviously, there's going to be an appeal in this case, so I understand that he's not going to waive his right, even though he has testified. Mr. Davis, I should note, did make a brief statement to the probation department, but again, just kind of a summation of his trial testimony, so.
Obviously, this is a tragic situation, Judge. Every person in this courtroom recognizes that this was a terrible loss of a little girl's young life. And my client certainly had a very close relationship with the victim in this matter, and he suffers dearly as well as a result of that loss. My client has, up to this point in his life, been an otherwise responsible, productive, law-abiding person. He does have a very limited criminal history. I think there is a 2016 conviction for a misdemeanor of the 4th degree involving improper handling of a firearm offense. There is a juvenile adjudication some 17 years ago. But other than that, he has no criminal history whatsoever. Always been productive, hardworking individual. And this is obviously a significant conviction in this case. We feel that the purposes and principles of sentencing would be served if the court would consider imposing the minimum sentence required by law, which I believe would be a life imprisonment with 15 plus 6 years in firearm specifications for a net 21 to life, and that's what we're asking you to consider imposing here.
All right, thank you, Mr. Bradley. Mr. Cumpstone, and again, Mr. Deaver, I know what your intention is, but I am obligated to ask if you'd like to make a statement on your own behalf at this time. Okay, thank you.
Thank you, Your Honor. May it please the court. Judge, as my co-counsel has put before you, this was a tragedy. There's no other way to describe the situation. Absolute tragedy. And frankly, there's loss all around. Everyone in this courtroom experiences the tremendous loss that resulted from this incident. You had the opportunity to sit through trial. You had the opportunity to hear the testimony of all the witnesses, hear the testimony of my client, Mr. Davis. Accordingly, I'm advising him, and because we're pursuing an appeal, I'll be advising him to not make a statement. I'm asking not to hold that against him, and that we won't.
Absolutely not, Mr. Cumpstone.
So, Judge, you also have the PSI in front of you, and on your review, I'm sure you're able to determine and note that my client does have some criminal history, but it's relatively minimal. Other than the few prior convictions that he does have, he's been generally otherwise a law-abiding citizen. He works. He testified that he was actually working a pretty impressive job in Florida. He's clearly a bright young man. He's got tremendous family support. He's in a long-term relationship. Judge, we would just ask you to take all this into consideration, especially considering the fact that there is a lengthy prison term that's coming here. And we do believe the principles and purposes of sentencing would be satisfied by the minimum term that Mr. Bradley outlined. So we would ask that you impose that minimum term.
All right, thank you, Mr. Cumpstone. Mr. Davis, again, I understand there's going to be an appeal in this case, and I do want to ask you, though, if you'd like to make a statement on your own behalf. Okay, and again, I understand. You both have been advised not to make statements. I did hear your trial testimony. It's not going to weigh at all in my sentencing. Do either of you have family members or anyone who would like to speak on your client's behalf at this time?
I believe on behalf of both young men
Sure.
here, we would ask the court to hear from our client's mother.
Certainly. So, ma'am, when you come up, just make sure you speak slowly and clearly so the court reporter can take everything down. I just need you to state and spell your name, okay?
is Toya Houston, Toyahouston.
All right, good morning, Ms. Houston. What would you like me to know?
This is a terrible tragedy for us all. Gracie was a part of us, just as well as she is a part of them. Neither one of them would have ever done anything to hurt her. They won't do anything to hurt anybody, first and foremost. They are great boys. We all are here for the same reason. We wanted justice for Gracie. That's what we were here for. And I feel that we didn't get that at all. And whatever the outcome is today, you know, we'll be willing to follow up with that. But right now, we need to deal with the facts at hand. They didn't do it. They didn't do it. They were protecting her just as well as they were protecting us. And no telling what would have happened if they didn't protect us. And we know the truth, and the truth will prevail itself. And I thank you, Your Honor, and I thank the court, and I hope that you take into consideration that they are not guilty.
Well, Ms. Houston, we heard from both of your boys
Yes.
in this trial. Are you saying that what they testified to was not the truth?
No, what I'm saying is what they testified to was that they were protecting their home.
I just wanted to make sure.
Yes.
All right, thank you.
Mhm.
Is there anybody else, Mr. Bradley or Mr. Comstone?
I don't believe so, Your Honor. Thank you.
No, Judge.
All right, thank you very much. On behalf of the state of Ohio, Mr. McNair.
Thank you, Judge. You know from presiding over this case, this is one of the most tragic cases that we've had the misfortune of seeing. They were shooting at their friends and they killed somebody they loved. I believe two of Gracie's family members wish to address the court.
All right, ma'am. When you come on up, just make sure you speak slowly and clearly so that our court reporter can take everything down. Just please state and spell your name.
My name is Touchou, Touchchoup. I'm a Gracie grandma.
What would you like me to know, Ms. Chu?
Thank you for your honor to allow me to speak on behalf of Gracie and my family. There are no words strong enough to carry the weight of the pain we feel. But I will try because Gracie's life deserves to be remembered and her loss echoed loudly in our family and community. Gracie was just 10 years old. She's in her 10 years, she's shown more love, more kindness, more forgiveness than many can show in lifetime. She was the girl that cared about people when no one was watching. She was light and shine too brightly, so brightly, an apple of our eyes. Gracie was the first daughter and the first and only granddaughter. She was the heartbeat of our family. In intent, she was taken from us, not from a stranger, but by someone she trusts, someone that she was supposed to feel safe around, someone who should have protected her, but instead betrayed her and betrayed us. You
Excuse
stay
me, ma'am, I'm sorry, Ms. Chu. Do not let her back in, thank you. I'm sorry, Ms. Chu, please continue.
You stay in my home, ate my food, and sit with us while we mourn the loss of our baby. That evil you caused this pain. We will never get to watch her grow up, well, never see her graduate. I will never get to hear her voice, "I love you, my Ye," again. No more birthday.
No more birthdays, no graduations, no driving lessons, no Christmas mornings, no wedding day. Just silence and a hole in our hearts that cannot be filled. There are no words for the kind of pain that comes from losing a child. But I hope today this court and this sentence speaks to the truth. That her life mattered, that her heart was rare, and that justice, whatever it looks like, must speak loudly enough for her, since she cannot speak for herself.
Thank you. Thank you, Ms. Chu. Mr. McNair, who else? Deputy, can you shut that door, please? All right, again, good morning, ma'am. If you could speak slowly and clearly and spell your name for the court reporter.
Good morning. My name is Melinda, Malindaudaugerty. I'm Gracie's grandmother on her father's side. Okay, sorry.
What would you like me to know?
Good morning, Your Honor. On behalf of Gracie's father, Jonathan Griffin, and our family, we would like to thank the Cleveland Police Department, the Homicide Unit, Metro Trauma Team, the Cuyahoga County Prosecutor's Office, and most importantly, our family, our friends, and our community for the prayers, support, and donations for our angel Gracie. Thank you for your time.
Thank you. Mr. McNair, is there anybody else?
No, Your Honor.
Okay. Before imposing sentence, the court's going to note for the record that I have considered the entire record, including the trial, testimony from all of the witnesses, including each of the defendants. The oral statements made here today, the pre-sentence investigation reports, the victim impact statements, and the statements from Mr. Deaver and Davis's mom. I've also considered the letters from family members that I've received and reviewed. And I must, and I have formulated my decision based upon the overriding purposes and principles of felony sentencing, namely to protect the public from future crime by the defendant or others, as well as to punish the offender using minimum sanctions that I determine accomplish those purposes without imposing an unnecessary burden on state or local government resources. To achieve these purposes, I have considered the need for incapacitation, deterrence, rehabilitation, and providing restitution. I must and I have considered the seriousness and the recidivism factors relevant to the offense and offender pursuant to revised code 2929.12. The court must and I have ensured the sentence being imposed does not demean the seriousness of the crime, the impact it has had on the victims, and is consistent with other similar offenses committed by like offenders. Finally, Mr. Deaver and Mr. Davis, the sentence I'm going to impose will not be based on any impermissible purposes, namely your race, ethnic background, gender, or religion. Do each of you understand that, Mr. Deaver and Mr. Davis? Okay. So before I impose sentence, I wanted to say a couple of things. This was a tragedy, and there's no doubt in my mind that every single person in this room, sitting on both sides of this aisle, loved and cared for both, not only Gracie Griffin, but also Mr. Deaver and Mr. Davis to some degree. But the fact of the matter is we're here because of a mistake that you made. We're here because of a terrible mistake that you made. And one of the things that bothered me throughout the trial testimony was this notion that the two of you live in a neighborhood filled with drive-by shootings and high crime and murders. You don't, okay? I lived in the city of Cleveland for almost 20 years. I lived in West Park, which is where you were. And I understand that a friend of yours was shot off of Trowbridge Avenue over near, I think it was West 38th Street, I think was the cross street that I had heard during trial testimony. But 38th and Trowbridge is not anything resembling 126th and Triscuit. That's a fairly quiet neighborhood. And while maybe it's not as peaceful as other parts of West Park, it is not the crime-ridden hellscape that the two of you testified to at trial. So that bothered me to some degree. The other part of this too is the individuals who were in the car were friends of yours. There was no testimony to the contrary that Mr. Stevens, Ms. Jackson, Ms. Rivera, and Ms. Williams were not friends of yours or targets of any kind of shooting. This was a mistake, a tragic mistake that had tragic consequences for the family of Gracie and for your families, as I'm required to give you a mandatory sentence here. So the court's going to sentence you as follows. I want to note for the record that none of these counts merge for the purposes of sentencing, so the court is going to impose a sentence on each count. That I also must note that pursuant to Ohio Revised Code, section 29.14B1G, as well as the presiding case law, State versus Baller, 22 Ohio 4310, that I am required to run the two of the 3-year firearm specifications consecutive with each other, regardless of any underlying merger. So the court's going to sentence each of you as follows. And count 1, the sentence is going to impose 3 years on the firearm specification, which must be served prior to and consecutive with a sentence of 15 years to life. In count number 2, I'm going to sentence you to a 3-year firearm specification, which must run prior to and consecutive with the 2-year sentence I'm going to impose on the felonious assault, and consecutive with the 3-year specification in count number 1. In count number 3, felonious assault for Micaiah Jackson. Count 2 was Jameer Stevens. Count 3 for Micaiah Jackson, I'm going to impose a sentence of 2 years. Count 4 for Giselle Rivera, I'm going to impose a sentence of 2 years. Count 5, with regard to Juwone Williams, I'm going to impose a sentence of 2 years. Count 6 for improper discharge into the habitation of Bella Ben, I'm going to impose a sentence of 2 years. In count 7, the discharge on or near a prohibited premises with regard to serious physical harm to persons, I'm going to impose a sentence of 3 years. And in count 8, the discharge on or near a prohibited premises, creating substantial risk of harm to property, I'm going to sentence you to 1 year each. I will note for the record that counts 2, 3, 4, and 5 will run concurrent with each other. Counts 7 and 8 will run concurrent with each other. And counts 1, 2, and 6 will run consecutive with each other for an aggregate sentence of 25 years to life. I'm going to note that the court finds consecutive sentences are necessary to protect the public from future crime and to punish the offenders, and that the consecutive sentences are not disproportionate to the seriousness of the offender's conduct and to the danger the offenders pose to the public. And I find with regard specifically to Mr. Deaver that at least 2 of the multiple offenses were committed as part of 1 or more courses of conduct, and the harm caused by 2 or more of the multiple offenses committed was so great or unusual that no single prison term for any of the offenses committed as part of any of the courses of conduct adequately reflect to the seriousness of the offender's conduct. And actually that will apply to both Mr. Deaver and Mr. Davis, But specifically to Mr. Davis, I'm also going to find that the offender committed one or more of the multiple offenses while he was awaiting trial or sentencing or under a sanction imposed pursuant to section 29, 29.16, 17, or 18 of the revised code. That's because, Mr. Davis, you were on probation to Judge Bell for having a weapon while under disability. The reason I'm giving consecutive sentences, I'll note, is that there's 3 groups of victims here. There's Gracie Griffin, the 4 individuals who were in the car. I believe that shooting at them deserves its own sentence, and the fact that you shot over a roadway on a busy and dense residential street, resulting in one of those bullets striking through a home, merits its own sentence as well. I do want to advise both of you that you have the right to appeal your conviction and sentence, and that's pursuant to Criminal Rule 32B. And I will advise the following: if you're unable to pay the cost of appeal, you have the right to appeal without payment. If you are unable to obtain counsel, counsel will be appointed without cost. If you're unable to pay a document cost of appeal, the same will be provided without cost. Each defendant has a right to have notice of appeal timely filed on his or her behalf, and upon your request, I will appoint counsel for appeal. Now, I spoke with Mr. Martin. I'm going to appoint counsel for both of you. Mr. Deaver, I'm going to appoint Susan Moran to represent you on your appeal, and Mr. Davis, I'm going to appoint Joe Pagano to represent you on your appeal. I'm also going to find that both of you are indigent. I'm going to waive your court costs for both of you. Mr. Deaver, you're going to be given credit for 356 days served. Mr. Davis, you're going to be given credit for 348 days served. Because this is a life sentence, I am not required to read and review the terms and conditions of post-release control. Mr. McNair, is there anything else on behalf of the state of Ohio?
No, Your Honor.
Mr. Bradley, is there anything on behalf of Mr. Deaver?
No, Your Honor.
And Mr. Cumpstone, anything on behalf of Mr. Davis?
No, Judge.
I want to thank all of you again for your time and care, and I want to thank everybody in the room for their decorum. Thank you, everybody. Have a good day. Good luck to you both.
Thanks, Pat.